Good morning, everyone. Welcome to today's Weltman webinar. Today's topic is protecting the creditor's interest in Chapter 11. My name is Scott Fink. I will be a panelist for the session today. Just a little bit about myself. I have been with the firm for about 19 years, been in practice in bankruptcy law for about 25 years. I head up the firm's bankruptcy group. I'm a partner in the firm here. And our bankruptcy team, you'll meet my fellow shareholder, Geoff Peters, in just a moment, who's a co-panelist. We are together with 4 other attorneys in our group, dedicated solely to bankruptcy practice, representing creditors. And we have a dedicated team that works with us, protecting your interests in bankruptcy cases all around the country. And we have, as many of you are probably aware, offices in several cities, and we have a national reach, both in bankruptcy and in the collection side as well. So without further ado, I'm going to go ahead and introduce Geoff Peters and let him tell you a little bit about himself.
Thank you, Scott. My name is Geoff Peters. I've been with the firm. It'll be 25 years in December. So I've seen a lot. It's my practice is limited to bankruptcy, even though I do some commercial litigation now in Florida. I am licensed in Ohio, New York, Florida, and Michigan. So I've seen a lot of, although we're under one bankruptcy law, there is a lot of different decisions out there, which makes it an interesting practice. But thanks for joining us.
Great, thank you, Geoff. All right, so before we get started, I'm going to take a moment to just go over a couple of housekeeping items for everybody. As a reminder, it's an interactive session, so please submit your questions to us through the question button in the control panel. The questions will be addressed during the presentation where we can, and I'm going to go ahead and right off the bat say we've got a huge group. We are going to do our best to answer, I'm going to say some of your questions, because oftentimes we'll get a whole bunch. This is a fairly ambitious agenda we've got today, which I'll walk through in a moment, and you'll see where there's a lot of ground we want to cover with you. So if we don't answer your question, don't fret. If you would please just shoot Geoff or I an email afterwards, and we will get to your question and deal with you personally. We're happy to do so, because you probably have some specific that may involve a specific account of yours, and we want to make sure we give you a personal touch if we can't get to it in the course of the presentation today. The webinar is being recorded. At the conclusion of the session, a link to the recording will be sent to all attendees. Lastly, there's going to be a short survey on your screen at the conclusion. Please take the survey and share your feedback with us. We do appreciate hearing your opinions on our webinars. So lastly, because we're lawyers, we have to read you our firm's webinar legal policy. So I'm going to get through it as quickly as possible, and then we can get into the topics. This seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. This seminar and the material provided is not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on this content as a source of legal advice. We advise you to seek competent legal advice on these topics. This seminar or seminar material does not create any attorney-client relationship between you or the law firm of Weltman, Weinberg & Reese. So with that said, at the outset, I'm just going to tell you how we'd like to structure this. I'm going to walk everybody through sort of a big picture, how the Chapter 11 process works, because it will probably help with some of the other more specific topics as we tie some things in for you. Then we're going to talk about some best practices to ensure getting payments as a creditor before the plan confirmation in Chapter 11. Then we're going to talk about leases versus loans in Chapter 11, how they're dealt with and how to protect yourself. And then finally, we're going to talk about preference demands, the dreaded, preference demand that some of you have probably seen from debtors, attorneys, or liquidating trustees or the like in Chapter 11 matters. So with that, the first topic we'll hit again is sort of how does a Chapter 11 work? So first of all, generally Chapter 11 bankruptcy provides for reorganization, usually involving a corporation or a partnership. A Chapter 11 debtor usually proposes a plan of reorganization to keep its business alive and to pay creditors over time. Individuals can also seek relief in Chapter 11. In addition to reorganization, You will see Chapter 11 cases that their primary goal is to liquidate assets, not really to reorganize. So Chapter 11 is initiated, like other bankruptcies, by the filing of a petition by the debtor, which also has to include a schedule of assets and liabilities, current income and expenses, a schedule of executory contracts and unexpired leases, and a statement of financial affairs. Upon the filing of a petition by the debtor, upon the filing of the petition for relief by the debtor and the entry by the court of an order for relief, the debtor automatically assumes an additional identity known as the quote-unquote debtor in possession. So this means the debtor keeps possession and control of its assets while undergoing a reorganization under Chapter 11. The debtor remains a debtor in possession until the Chapter 11 plan is confirmed, or the case is dismissed or converted to another chapter, or a Chapter 11 trustee is appointed. As a debtor in possession, the debtor is legally charged with the rights, duties, and obligations of a trustee in dealing with the debtor's property, operating the debtor's business for the benefit of its creditors and its interest holders. The debtor in possession is also responsible for accounting for property, examining and objecting to claims, and filing informational reports, as well as filing tax returns. The debtor in possession has the right, with the court's approval, to employ attorneys, accountants, appraisers, auctioneers, or other professionals to assist the debtor during its bankruptcy case. Now, the automatic stay operates and functions just as it does in Chapter 11, as it does under other chapters of the code. There is, however, no co-debtor stay in Chapter 11. Only an automatic stay as to the debtor itself. At the outset of the case, the debtor will usually file a series of what are called first day motions. These seek authority for things like using cash collateral, to pay pre-petition wages and benefits of their employees, to pay critical vendor claims, to pay ongoing sales and use taxes and things of that nature. Debtor in possession can also use, sell, or lease property of the estate in the ordinary course of its business without prior approval unless the court orders otherwise. However, a debtor in possession may not use cash collateral without the consent of the secured party or authorization by the court. So in order for a debtor in possession to obtain permission to use cash collateral, it must normally provide adequate protection to the secured party. This is usually in the form of periodic payments of cash and or replacement liens. So cash collateral, which we've referred to that a couple times, it's defined as cash, negotiable instruments, documents of title, securities, deposit accounts, or other cash equivalents in which both the debtor and another entity have an interest. So approximately 30 to 45 days after the Chapter 11 case is filed, the first meeting of creditors will take place. The United States trustee is responsible for monitoring the debtor's operation of its business, compliance with the reporting requirements of Chapter 11, and payment of fees. The United States trustee also monitors application for compensation, reimbursement by professionals, and it reviews and has grounds to object to the plan and disclosure statement, and it monitors the conduct of the creditors committees. The United States trustee conducts the 341 meeting of creditors and may question the debtor under oath regarding the debtor's conduct, acts, property, and case administration. Although the appointment of a case trustee, as opposed to the U.S. trustee, a case trustee is a rarity in Chapter 11, a party in interest or the United States trustee can request the appointment of a specific case trustee or an examiner at any point prior to confirmation in a Chapter 11. The court, on motion of a party in interest or the U.S. trustee, and after giving notice and having a hearing, can order the appointment of a case trustee for cause, including things like fraud, dishonesty, incompetence, or gross mismanagement of the debtor, or if such an appointment is in the interest of creditors, equity security holders, or other interests of the estate. If the debtor in possession fails to pay quarterly fees, which are required to be paid to the U.S. trustee, if it fails to adhere to the reporting requirements of Chapter 11, or if it fails to move the case along towards confirmation, the U.S. trustee or the Chapter 11 case trustee, in the case one is appointed, does have grounds to bring a motion to convert the case to another chapter or to dismiss the case. All right, so moving on. The debtor in possession has a 120-day, what's called exclusivity period, within which it alone has the right to file a plan of reorganization. It does have a right to seek extensions of that exclusivity period as well. After that exclusivity period runs out, any interested party, including a creditor, the United States trustee or an equity security holder can file a plan in the place of the debtor. The plan of reorganization is a proposal. It's a proposal as to the treatment of the various claims and interests of the debtor in possession. It includes details as to how each class will be repaid. The plan has to designate classes of claims and interests for treatment under the reorganization. Generally, a plan is going to provide the following classes. You're going to have secured creditors, unsecured creditors who have priority, they're entitled to priority, general unsecured creditors, and equity security holders. Those are your four main ones. Before there can be a vote on confirmation of the plan, the debtor in possession or whoever proposed the plan needs to file and get approval of a disclosure statement, which has to provide adequate information concerning the affairs of the debtor that enables the holder of a claim, creditor in your case, to make an informed judgment about the plan. Then creditors and parties in interest can object to the adequacy of the disclosure statement, and then a hearing is ultimately held to consider approval of that disclosure statement and any objections that are filed as to it. Once the disclosure statement's been approved, creditors now will have an opportunity to file objections to the plan prior to the objection deadline. And unless resolved by agreement, those objections must be prosecuted at the plan confirmation hearing in order to have the plan confirmed. The plan also has to provide for acceptance or rejection of all leases and executory contracts. The plan proponent can modify the plan at any time before plan confirmation. Court will ultimately hold a hearing on plan confirmation and has to make a determination that the plan's been proposed in good faith, that all requirements of confirmation have set forth in the bankruptcy code have been met. And in order for a plan to be considered feasible, which is one of the requirements, the court has to find that the plan's not likely to be followed by liquidation, assuming it's a reorganization plan. Also, for a plan to be confirmed, each class of claims must vote in favor of the plan through a ballot system, whereby each creditor and interest holder is provided with a ballot and it seeks their acceptance or rejection of the plan. Those ballots are tabulated by the debtor's attorney, and they need to establish that each class has voted in favor. Once the plan is confirmed, the debtor is required to make plan payments and is bound by the provisions of that plan of reorganization. The confirmed plan creates new contractual rights, replacing or superseding pre-bankruptcy contracts that it had with its creditors. Confirmation of the plan normally discharges a debtor from any debt that arose before the date of confirmation, except for those debts that were deemed non-dischargeable under Section 523 of the code. A discharge is not available to an individual debtor, so a person, unless and until all payments have been made under the plan. Likewise, an individual who files and has a liquidating plan confirmed will only receive a discharge once they've made all their plan payments, which can carry on for a series of years after the plan's been confirmed. For all other Chapter 11 cases, confirmation does not discharge the debtor if the plan is a liquidation plan as opposed to one of reorganization. So with all that being said, I'm going to go ahead and just a couple of big picture sort of questions that comes out of all of that. One that I think is important for all creditors to consider. You're asking yourself, what are the key times or points during a Chapter 11 where retention of counsel would be most important? When should you really be seeking advice of counsel? Geoff, you have thoughts on that? I've been talking a lot.
Well, a Chapter 11 is a very different animal. So if you as a creditor don't have a lot of experience with a Chapter 11, we're always happy to again go over the process with you, go over the key points. But really, depending on your collateral, how big your account is, how big your claim is, you really should seek counsel right away, because there's some like Scott mentioned, the first day orders. There's some things that can be binding on you within the first couple days of the case. So, and again, if you're not getting paid on an asset and want to get paid, Chapter 11 usually a debtor is trying to hold on to its cash, and unless you file a motion with the court, you're not going to get paid until the plan confirms. So yeah, I think you need to seek counsel right away on a lot of these Chapter 11 cases. Scott?
Yeah, I would. The only thing I would add is I completely agree with Geoff. This is an area of law where you can get caught with your pants down, so to speak, as a creditor if you do not have somebody looking out for your interests right from the beginning. But that being said, if you are in a situation where you you're going in a loan for a while. A couple of the big ticket items that I would say you need to be aware of to make sure that you have counsel involved. If you have cash collateral serving, as security for your account or your loans, that's a big one, because that is going to be part of those first day motions and orders. You got to make sure that if the debtor is going to use your cash, that you are being adequately protected, either through a replacement lien or hopefully, most likely, some form of periodic cash payments to you in exchange for allowing that debtor to use their cash to operate the business. And it's, quite frankly, a huge leverage point for you right at the beginning of the case to call your shot, because if the debtor can't use their cash, the case isn't going to go very far. It's kind of doomed from the start. And if you want to assert yourself early, that is a good time to do it. But that's, of course, specific to if you have loans. Oftentimes it's those blanket liens where not only do you have specific equipment or vehicles or real estate securing the loan, you may have the accounts of the debtor securing your loan. Those are those situations where that'll crop up. Other big ones would be, as Geoff alluded to, if you are not seeing payments from the debtor initially, it's because they're trying to hold on to their cash. We should probably be looking at negotiating adequate protection payments for you if you're a secured creditor. We'll get into that a little bit more as we go forward, but early on in the case, if you're not seeing payments and you're getting nervous about it, that's a good time to seek representation. If you've got a lease situation, negotiating assumption of that lease is another big point where you want to have counsel protecting your interests. And then, of course, the plan itself, when a plan gets filed, I would highly recommend you have counsel to review that plan for you and provide you with an analysis to whether or not you are being provided for properly, treated properly, or if an objection needs to be filed on your behalf. Let's see. I will briefly ask this one. This one's a pretty straightforward one. How do I know whether I need to file a proof of claim in a Chapter 11 case? Geoff, you want to touch on that real quick?
Well, yeah. So it's always good practice to file a proof of claim in every Chapter 11. That's always going to be our recommendation. But if sometimes you miss that deadline, and we always the bankruptcy code and rules does indicate that a creditor is not required to file a proof of claim if they agree with what's on the schedules. So and if what's on the schedules is not marked as disputed or unliquidated or contingent.
Yep.
But so a lot of times creditors won't have access to those schedules, so it's just better practice to always file a proof of claim.
Yeah, I absolutely agree, and that's been our advice to clients throughout the years: is that don't assume anything. It's better to get your version of the claim in there. It'll supersede anything that the debtor has scheduled you as. And then I think that's a good segue to sort of move into the next section, which we're calling sort of best practices to ensure payments as a creditor before the plan confirms. So the first big one, of course, as we just said, is ask yourself the question: did you file a proof of claim? If you do file a claim, it will supersede anything that the debtor schedules you at or what they believe is owed. Your proof of claim setting forth what you believe is owed, whether it's pre-petition, sort of back payments that are owed, or the full balance your claim is going to control. And it's on the debtor then, it's their obligation, if they dispute that, to object to your claim, and we can have that fight with them later. But that first big one to ensure payment would be get a proof of claim file. The second big picture item I want to make sure that everyone is aware of: did anyone file a notice of appearance on your behalf? And the reason for that, a notice of appearance is exactly what it sounds like. It is somebody notifying the court, the debtor, debtor's counsel, other creditors, other interested parties, that someone is appearing on your behalf in the case. And that will allow for any pertinent documents and pleadings that are filed in the case to be sent to your representative, whether it's our firm or another firm, or it allows you to be kept in the loop, or your counsel to be kept in the loop as to anything that is going on in the case. And that is where, if you don't do that, what you're forced with is trying to go onto the docket and look for things on a daily basis. And some of these Chapter 11s, for anyone who has any experience in them, they can get very large, very fast as far as the number of pleadings that you have to sift through, and your eyes will glaze over. It's better to be on the service list so that you are receiving those things, or your counsel is receiving that stuff. Because things that can pop up would be motions that propose to sell your collateral as part of a larger sale, or motions to avoid your liens on collateral as part of a larger sale or an avoidance action. Those are big ones that if you're asleep at the wheel and you don't have somebody either protecting your interests or entering an appearance on your behalf, once that stuff gets entered, it's very hard to undo it. So, big practice point there as far as protecting your interests in a case. Geoff, any thoughts before I go on to the next?
No.
Okay, so the next big question I often have our clients ask, or I ask our clients, or ask myself, is your claim secured by collateral, or is it an unsecured claim? Makes a big difference in terms of what your rights are to get paid in the short term before a plan gets confirmed, and whether you are entitled to pre-confirmation, what are called adequate protection payments, things like that. So if you are secured by collateral, Geoff, why don't you, some of your thoughts on what the client should be asking themselves, what we're looking for, and the ways that we can protect their interests if they're secured.
Sure. So one of the first things we look at is your documents. Do you have a security interest in the collateral? So that's the first question. The second big question is, are you perfected in that? So a perfection is, do you have a UCC filing if it's personal property? Do you have a lien on the certificate of title if it's a car? Those types of questions. Because if you are not perfected, the debtor can avoid that security interest and treat you as unsecured. So that's the first thing we look at. And if you are properly secured, is your collateral depreciating? Is it losing value because the stay is in effect and you can't collect any money? If that is the case, we can file a motion with the court to ask for what's called adequate protection payments, which is the amount your collateral is depreciating while the stay is in effect. So those are the first things we look at. Second,
also add,
oh, go ahead.
I was saying, in terms of the depreciation, another corresponding question that we will look at is the value of your collateral itself. Are you oversecured, basically? Is it a situation where you've got so much equity in this collateral, even though it may be depreciating, we're starting from a very high point, you may not be entitled to adequate protection in those situations, possibly, where the debtor may turn around if we ask for adequate protection, and their position may be, no, the equity cushion is your adequate protection. So does it happen a lot? No, but it does happen.
And the only thought I'll put out there theoretically that was taught in one of my bankruptcy courses is there's a small amount of jurisdictions that say, hey, if you have a certain equity cushion there, the creditor should be able to maintain that equity cushion. So if they have $25,000 in equity, we should be able to keep going with that. A lot of the courts may not agree with that, but there are some out there that do. So it's one of those things that I mentioned early on. I have licenses all over the place, and there's a lot of different decisions on these issues.
Another big piece to ask yourself right from the beginning, if you are secured, is there insurance on your collateral? Now, I will say that the debtor is required to prove that they have insurance. Does that mean they always do? No. I think this is a function of, some of the more complex cases, and you have more complex, experienced attorneys that are representing them in larger cases. It's almost a foregone conclusion. They're going to make sure that their clients have the collateral insured. But I've seen many cases that are smaller Chapter 11s where that slips through the cracks, or there's not as much communication between the debtor and its counsel, and lo and behold, debtor hasn't done what they're supposed to do. That basic sort of thing you would think they would do at the beginning, which is make sure all the collateral is insured so they can prove that to the United States trustee. they either haven't done it or they don't have the cash to do it, that's a huge red flag right from the beginning, that we need to make sure we're checking that box for you to ensure that you have proper insurance on your collateral, because that'll be a nightmare if you don't and the stuff is damaged and there's nowhere to turn. So as we indicated, is your claim secured by cash collateral? That's another sort of offshoot of, is it secured by collateral? And if it is in fact secured by cash collateral, that's where we want to get in on the ground floor, negotiate an adequate protection payment for you in exchange for allowing the debtor to use that cash going forward. And they should be paying you, whether it's, depending on the situation, they could be paying you weekly, bi-weekly, monthly, whatever term is appropriate based on, your loan with them, the bigger picture of other creditors that they have, other claims that are out there as to the cash collateral. It's something to be negotiated. And as far as those adequate protection payments that Geoff was referring to with, taking into account and compensating you for that depreciation, I've really looked at it. I tend to take a pretty hard line stance at the beginning. If I can negotiate a situation with a debtor's attorney to just say, pay us a contract payment. Just keep paying us what the contract stated. If it's, $1,000 a month, we want $1,000 a month as that adequate protection. Some counsel will be fine with that, but as Geoff alluded to, cash is important to these debtors, especially in the early part of their case. So they may push back on that and say, no, that's actually not the number that's proper to compensate you for depreciation. So then you start getting into, what is the proper amount to compensate a creditor for depreciation of its asset? I've seen all kinds of calculations out there. I think one of the standard ones is the thinking of 1 to 1.5% of the value of your collateral per month. I've seen that. I've seen, parties agree on interest only to sort of leave your loan in a, it's not, the principal balance is staying as it is, but there's no more interest accruing. I've seen it done that way. Geoff, any other thoughts on, ways that you've addressed it or seen other creditors address it?
Yeah, what I actually typically try to do is, for both my sake and attorney's fees and all that, is to try to negotiate both an adequate protection payment and or the plan treatment. Because once the case is filed, even sometimes before the case is filed, that debtor is reaching out to the creditors to try to negotiate some type of deals, because there is an end game here. So when I get a request from our client for payments, I come right in and say, hey, let's negotiate the plan treatment. Let's value the vehicle or the equipment and get the amortization schedule started. And so you can start payments now, and they complete in 3 years or 5 years. So, and a lot of times that will work, but if cash is really scarce, then it may not, because they're trying to hold on to every dime.
Yeah, and I'd say it's also an ideal time if you're a lessor, ideal time to try to negotiate that lease assumption as well. If you're in a situation where payments have not started on your lease and you're interested in making sure they resume payments, knock that out as well if you can. I mean, there's plenty of situations where they are not prepared to make that decision on formally assuming, but you'll certainly be able to negotiate adequate protection payments, which to me is the lease payment itself. I'm not usually, not too keen on lowering that payment amount. The lease payment's the lease payment, and you need to start paying it, which we'll get into that a little bit more in one of the next sections. But let's say, for argument's sake, you've got a situation where you are secured. You have reached out, or through counsel reached out to debtors counsel and said, hey, we want to start payments. We're secured and we want to get some adequate protection payments going. And either they refuse or they're unable to. What's your next step there? And normally our position would be, this is a prime time to file a motion with the court asking for relief from the automatic stay to repossess and sell your collateral, or enforce adequate protection on the debtor, where they have to provide adequate protection. It could be one motion. It's essentially giving the debtor the either or situation. Give us back our collateral or provide adequate protection and let the court order it. So that to me is the prime time to do it. You know, it depends a little bit if we're talking about a lease versus a true secured situation. There's a grace period that's built in for leases in Chapter 11 where they've got 60 days to kind of make up their mind. So if you're trying to file that motion within the first 60 days, you're going to basically be put off and told wait the 60 days. But once you get beyond day 60, if they're refusing to engage you in payments, I think that's prime time to go ahead and file a motion. And a secured situation, Jeff, I mean, do you have a rule of thumb that you use as far as how far you'll let an account go out for a client before you advise them to file a motion?
Well, on a lease, I always tell the client, especially if it's a personal property lease, that they should be aware of that 60 days. So I'll make sure that the hearing is not scheduled within those first 60 days. And again, I'd reach out. Normally, before filing a motion, you're going to reach out to counsel and say, hey, have you made any decisions on the leases yet? We want to make sure this is getting paid and see what their response is. And then I review that with our client on whether they're comfortable with this or if we want to get a motion with a hearing date set after that 60-day period.
Yep, excellent point. So a couple of other areas where I want to touch on as far as getting paid, especially in the early portion. So a big question to ask yourself: did you ship any goods? This would be, a lot of times for an unsecured creditor, did you ship any goods to the debtor within the 20 days before the bankruptcy filing? That may very well lead to what's called an administrative priority claim. It gives you a higher priority of repayment if you in fact fit into that category of someone who has shipped and provided goods to the debtor in that 20-day period. Another potential would be if the debtor has received goods from you within the 45 days before the bankruptcy filing, you may have a reclamation claim for goods that were sold within the ordinary course of business while the debtor was insolvent. You have to have made a written demand for reclamation, has to have been sent to the debtor either within 45 days of receipt of the goods by the debtor or within 20 days after the bankruptcy filing. But if you have done that and you fit into that category, you may be entitled to reclaim your goods from them. So yes, that may not get you paid, but it gets you your goods back so you can resell them, or more likely it forces the debtor to pay you. One other item I'll mention is asking yourself, and this really is, it involves probably counsel and talking with opposing counsel, are you what would be potentially deemed a critical vendor of this debtor? So do you have a very specialized good or service that you provide to the debtor that nobody else can provide, and it's so important that the business really can't function without you? You may, and I say may, be able to, through negotiation with debtor's counsel, be deemed what's called a critical vendor. If you are lucky enough to be deemed a critical vendor, it's lucky and unlucky, you can have all of your pre-petition, anything that they've missed paying you up to the date of filing, as well as any payments that are behind now after filing, you can have that all brought current immediately, basically as a priority. But you do have to give them some preferential terms as far as going forward in shipping goods and accepting payments from them. Jeff, anything I'm leaving out in those areas?
Other than some jurisdictions, some debtor-friendly jurisdictions, and I'll say like Delaware and New York, they'll allow those critical vendor payments. There's other jurisdictions out there that may have a hearing and put the debtor to the test to actually show it's critical, and there's nobody else out there that can supply those goods that they're getting from this creditor that wants to get paid their pre-petition amounts. So again, this is one of those know your jurisdictions.
Yeah, and for us, I'll say know your industries, which it's one of the fascinating parts of Chapter 11 to me is there are so many different businesses that we encounter and so many different processes and inputs that go into producing some of these goods that you learn something new in every case about a particular item that is so key to that debtor's operation. I didn't know that those things existed before. And oh, lo and behold, you may find that it's very unique. You may find that there are plenty of vendors out there that provide that good. But it's a learning situation for us, and sometimes for our clients as well, to determine whether you truly are critical or not. All right, so we talked about, let's see if there's any question here. No, I mean, I think we've hit all that. I think it's as good a time as any. We're gonna move on to leases versus loans in Chapter 11. I'm gonna let Geoff sort of lead off with that to walk us through the differences and the ways to protect yourself.
Okay, so thank you, Scott. So with a lease, just because you have a document that says I'm a lease doesn't necessarily mean it is a lease. The bankruptcy code does distinguish between a lease, a true lease, and a secure transaction. A lease is going to get much better protection under the bankruptcy code than a finance or secure transaction. It's just written that way in the bankruptcy code. So with a true lease, the creditor actually owns the personal property, and that personal property is not part of the debtor's estate, just the contract is. So for example, in your ordinary individual transaction, you lease a vehicle from a dealership. If you ever noticed in Ohio, at least, when you look at the title, the creditor's name is listed as the owner on the title, not yours. So from a bankruptcy perspective, that vehicle would not be part of the bankruptcy estate, but that lease contract is part of the bankruptcy estate. So how do you determine if your document that says lease agreement is in fact a lease agreement or what's called a disguised finance transaction? And again, you want to be a lease under the bankruptcy code. And just from a practical perspective, whenever I have a document that says lease on it, I'm always reaching out to debtors counsel and saying, hey, what are you going to do about this lease? It's going to be their burden to show that that you're not afforded the protections under the bankruptcy code, that this is a lease, that perhaps it's a disguised financing transaction. So how do you determine if something's a lease versus a secure transaction? The Uniform Commercial Code actually has different standards to look at. And what the Uniform Commercial Code is, it's a recommendation of what the law on secure transaction should be. Actually, secure transaction is just one of the sections under the UCC, but states actually have to adopt the recommendations within the Uniform Commercial Code. So I think in the early 2000s, the UCC came out with this latest edition, and just about every state I know of did adopt their recommendations, and it's part of their state law. So some of the things that are included is, can the lessee or debtor terminate the agreement before the expiration of the initial lease term? So if they cannot terminate the lease and it has to go out for the full lease term, it may not be a lease, it may be a disguised financing transaction. Also, if the original lease term is equal to or greater than the remaining economic life of the goods. So for example, if your goods are only going to last for 5 years and your lease is 5 years out, and there's no value going to be left after the termination of the lease, then this probably isn't a lease. It's a financing transaction. I would note that a lot of creditors set things up as leases because they can deduct full lease payments on their tax returns versus if something's a financing agreement, they have to go pursuant to the depreciation schedules under the IRS code. So there's some tax advantages for setting things up as a lease. Another test to determine if this is a lease versus a disguised financing transaction is whether the debtor is bound to renew the lease for the remaining economic life. If they have to keep going forward, then it may not be a lease. Does the debtor have the option to renew for the remaining economic life for no or additional no or some nominal consideration. Again, if it that's probably not a lease. Does the debtor have the option to become the owner of the goods for little consideration at the end? So if anybody has seen what's called a dollar out lease, so at the end of a lease, a 5-year lease or a 3-year lease, that at the end the debtor has an option to buy that for $1. Probably not a lease, probably a disguised financing transaction. So if going through this test, you actually do have a lease, the debtor can either assume or reject that lease as part of the bankruptcy. And what they would do is they would file a motion with the court saying that they do want to assume or reject the lease, and the court ultimately has to approve that. If the debtor assumes the lease, the motion should set out what's being the cure amount. So if there's any default, any past due payments under the lease, that should be set out in the motion. And obviously the creditor would be served with that motion and would have an opportunity to object if the cure amount is incorrect.
Which I will just interject and say there's a big point right there to say, make sure you have counsel involved in that process. Those motions sometimes are huge. Omnibus motions to assume a whole slew of leases. You could be buried 100 pages in there, just in a schedule, and there you are on line, 723, and there's just one line for your lease and with a cure amount. Regardless of that, there's an obligation, you need to review it. And if it's wrong, you could be bound. You could be stuck. If they say that the cure amount is only $1,000, and the cure amount's $10,000, we need to get out in front of that. We don't want you stuck in a situation where they go, well, you had your option, or you had your opportunity to object to the cure amount, and you didn't. A big time to make sure you've got counsel reviewing for you.
And also along that point, a lot of, in some of the bigger cases, you'll see a motion to assume and assign a lease. And again, like as Scott said, that past due amount is maybe critical, because if you don't catch it, it's gone. When a lease is assumed, it has to be assumed in its entirety. So if a lease has 5 different pieces of equipment, you can't cherry pick what you want and what you don't want. So that's one of the powerful provisions under the bankruptcy code, is that you either take it all or reject it all. And you either pay it according to the contract or reject it. You can't negotiate. You can't do anything in terms of the original provisions in the contract. So that comes to both the payments as well as the other contractual terms within the lease. If the debtor files a motion to reject the lease, it is rejected in its entirety. It's considered as rejected as of the day before the bankruptcy case. So you would put once it is rejected, the automatic stay is lifted, so a creditor can just go out and get their collateral and file a proof of claim based on the rejection damages, which is basically what the amount is left under the lease contract.
Okay, I just for a second, for anyone who's on the line who may have a lease, if they're a landlord, it's a lease of real property, there's a cap on those damages. If in fact they reject your lease, it's not necessarily, you're not necessarily going to get a claim for all the remaining lease payments that were left. It's, I believe is it the greater or lesser? It's 15% of the remaining term up to 3 years, or 1 year's worth of lease payments. That's your cap.
I always have to look that up in the statute.
Yeah, I do too. I always have to go back and, okay, now what was it again? The 15% always gets me. But yeah, that's specific as to leases of real property?
There are some deadlines. Typically, a debtor has until plan confirmation to assume or reject a lease. There are some exceptions to that. A commercial lease, for example, the debtor has 120 days to assume a commercial lease, and that can be extended up to 90 days. But generally, with lease assumptions, it's up until confirmation. Years ago, and it still may be going on, but years ago that a creditor might have filed a motion to compel a lease assumption or to fix a time period in which to assume a lease or reject a lease. But there's a lot of case law out there that basically rejects that and gives the debtor until plan confirmation. And the reason for that is once a debtor assumes a lease, it's assumed. They can't get out of it. Also, if the debtor converts to a Chapter 7, for example, and they assumed the lease in a Chapter 11, it's still assumed in the Chapter 7 case. So that the debtor would be bound, and perhaps the trustee would be bound to pay on the ongoing lease. So that's the reason that the courts have shied away from requiring the debtors to assume or reject earlier than plan confirmation.
Quick question, Jeff, about these leases when they get rejected. If you got a situation or scenario where you got a client, they've got whatever, let's say a lease of a couple of tractors or forklifts or larger equipment that the debtor has actually used for several months, and then they get rejected, but they never got paid during that time. Do they have any special rights to get compensated for that period of time throughout the case when they were using the equipment without paying for it?
Yeah, there is. We could, as long as it was used in the business of the debtor, you can request that you be paid as an administrative expense within the bankruptcy case. But it is your burden to show that they were actually using the equipment and it did provide a benefit. That's why it's important, if you do have a lease, that you monitor to make sure that the debtor is making those payments, because again, under the bankruptcy code, they should be making those ongoing lease payments regardless of whether they've assumed the contract. So if it's still pending, they haven't made a decision on whether to assume or reject, they should still be making those payments. And as we referenced in an earlier section, if it's a personal property lease, they do have the 60-day time frame to determine whether they want to keep that lease or not. So.
Well, I'm going to pose a question while we're just real quick. So we keep referring to, the assumption of these leases. Have you seen, are there different ways that you have seen in different jurisdictions that courts have allowed these leases to be formally assumed, whether it's by stipulation, motions to approve? I personally, I've seen different ways depending on the judge, depending on the court. I mean, I get it. Ultimately, the plan is the thing that controls, but that sort of run up to the plan where you're negotiating that and memorializing it in some way.
Yeah, so I've seen it a lot of different ways, by motion or stipulation, but a lot of times the debtor has to show that it's in the estate's best interest to assume this lease. So there are parties out there that can object and say, hey, this isn't worth it. It may be difficult because the courts use the standard of a business judgment rule, but that's one thing you got to be careful about, is it should be properly noticed. So even if you have a stipulation, you may have to propose that stipulation to the creditors to see if anybody objects within a certain time frame. But yeah, there's different ways you can assume, whether it be by the debtor's motion, stipulation, or via the plan route, confirming a plan. So what happens if your lease is not a lease, but it's a disguised financing transaction? Then we just revert to what Scott said, what we were discussing, Scott and I, about adequate protection. You still may be secured at that point. At that point, you're not going to be paid unless you file your motion for adequate protection, or if you want to wait until plan confirmation. With any secured claim, you could, well, with most secured claims, you could be crammed down to the value. You can get re-amortized over a longer time period than your original contract, all of that. So you would have to take the affirmative step of filing the motion for relief from stay and or adequate protection. And obviously, once a plan is filed, you need to review to make sure you agree with the plan treatment of value, payments, all that. So,
Oh, good.
I was just gonna say that's what I had on leases. So I don't know if there's any questions in the chat room. I can't see that, but
yeah, there aren't any yet. I will say if anybody does have questions, feel free to shoot them in there. I know it's a lot to take in, so we're trying to get as much information out to you as we can, and I'll throw out one that I think here's your common sense question that I'm sure everyone would say, like, okay, so once my lease is rejected, if I'm a creditor, it's rejected by the debtor, what are my next steps? What should I be doing?
Yeah, so when rejected, it is the stay is lifted. So you should be contacting the debtor the debtor's counsel as to surrender arrangements of that collateral, and file your proof of claim for your rejection damages, and liquidate your collateral, take the steps to liquidate.
Yep, and I'll say, when it comes to my experience has been, yes, we always want to try to go through the debtor's counsel when it comes to, hey, we need to go get our collateral back. Oftentimes what will end up happening is through counsel, we can negotiate with debtor's counsel that neither side really needs to be involved on the attorney side when it just comes to communicating with the landlord at that site or the owner of the business. You guys probably have a much better contact than we ever would, or opposing counsel would, to get the day-to-day business done of sending an agent out to recover the equipment, secure it, make sure it's properly loaded onto a truck and it's brought out of there, or whatever it may be. Often we can just get an agreement with debtor's counsel that says, hey, it's cool. Here's the main contact. Your client can call my client and work it out and get the stuff back. And that's what I usually shoot for whenever I get these rejection situations is, can we cut the middlemen out? My client calls your client and as quickly as possible secure that equipment. And very rarely do I get any pushback. I don't think debtors counsels are too interested in having to get into the weeds on, negotiating a date and time when an agent's going to show up to take something. So that's a plus. All right, so we've got a very short period of time left. Geoff, do you want to tackle preferences? Walk
Sure.
them through that.
Yeah, sure. And this is a pain point for our clients. So a preference is, they may have collected all kind of money prior to the bankruptcy case, and lo and behold, the debtor files bankruptcy and they want that money back. So it's very painful. And us as a creditor's rights firm, we may have taken steps to, get a big win for our client. We got to give it back. Preference is it's there just so one creditor doesn't get preferential treatment over another creditor. That I think that's basically how it came about. So I mean, a typical example is debtor pays his friend 10 grand that he owes him before filing and then files bankruptcy right away. Well, that's not fair. So the trustee has the ability to sue the friend for that $10,000, bring it back into the estate and distribute it amongst everybody. So nobody, again, gets that preferential treatment. A preference is not mandatory. The trustee can decide whether or not, they want to recover it. taking into account the defenses a creditor may have. So an example of when the trustee may not avoid a transfer is, well, we just went through it during the pandemic. What we heard from a lot of our clients is, hey, we gave this loan on a vehicle, but we can't get the lien timely filed within the 30 days required by the statute. Well, I don't think there was any legislation that I know of that extended that date, but also during that time, I haven't seen many preference actions to avoid that. There might be some out there, but I'm not aware of those. But the elements a trustee must prove is that one, there was a transfer of interest, and that can include money that was transferred, property transferred, liens transferred. It has to be for the benefit of the creditor, which it usually is, not hard to show. Must be for an antecedent debt owed by the debtor prior to the transfer. Must be made while the debtor was insolvent. And that's an easy one to prove because the bankruptcy code provides that the debtor is assumed to be insolvent within 90 days of the bankruptcy filing. The transfer must have been made on or within 90 days before the bankruptcy case. So the trustee would count how much money the creditor received within those 90 days. If an insider is involved, so if the debtor paid a relative or the corporation paid a director or officer of a corporation, the dates increase. So that would be between 90 days and 1 year of the bankruptcy filing. And the last one is the transfer must enable the creditor to receive more than they would in a Chapter 7. So, I mean, I think the best example of that is right before bankruptcy, the debtor pays the car down, pays their car off for a $10,000 car. They pay the last $3,000 on it, and the car's worth like $10,000, for example. Well, that's not a preferential transfer because the car's worth more than the creditor received. So in a Chapter 7, the creditor would have gotten the full value of their vehicle because that's what it's worth. It's worth more than what was paid on it. So I'll go quickly through the four major defenses to a preference action. The first one is a contemporaneous exchange for new value. So basically that's the debtor paid some money and got something immediately back in return. And it does have to be immediate. It can't say, I'm going to give you 10 grand and give me something in the next 30 days. It has to be contemporaneous. Next one is payment was made by the debtor in the ordinary course of business or made according to ordinary business terms. An example of this is if you're a supplier and you supply goods and the terms are that you get paid within 30 days and the debtor pays within those 30 days, that's ordinary business terms. The ordinary course of business, on some of the larger preference actions, we may hire an expert to look into a industry as to when payments are generally made in a certain industry. And those are very expensive reports, so those aren't used in smaller cases, but they'll provide a detail to support your defenses. A third defense is that the debt creates a new security interest. The best example of that is buying a car. Debtor pays for a car, and you're secured by that car, and you have to place your lien within 30 days. And the last defense is new value given for a transfer. And an example of that is you have an open line of credit. Debtor pays, for example, $50,000 on that line, and because of that payment, you extend new credit terms, or you allow them to borrow additional money. But for that payment, you wouldn't have extended those terms. So the bankruptcy code looks at that and says, hey, that's an exception, and the new value exception that the trustee would not prevail in that case. So
all right,
that's what
so we're up against the time here. What I'm going to say is, for preferences, This is an area, don't just roll and pay a trustee or a debtor's counsel when you get one of those demands. At least reach out to us. We will review it. It doesn't cost you anything to have us analyze it and tell you whether we think you have some defenses, and then you can go from there. I wouldn't just pay it sight unseen. I did see one quick question I want to answer. Someone asked a question, if they have a UCC lien that's set to expire during a pending bankruptcy, can they renew it? The answer is yes. You can renew your lien, that an existing UCC lien that's not considered a violation of the automatic stay, to renew an existing lien. So I want to make sure I got that one out there. So with that, we covered a lot of ground. I appreciate everybody's patience and bearing with us. We hope we imparted some good knowledge on you. If you have other questions you want to ask us specifically offline, you've got our contact information there, phone, email, the whole thing. We would welcome hearing from any of you. I want to thank all of you for attending today's webinar. We hope you found the presentation informative. As a reminder, there's going to be a short survey that's going to pop up on your screen when the webinar ends. Please share your feedback and let us know what future topics you would like to see. I also want to share that we have a complimentary library of over 30 webinars that you and your team can view on demand. Our collection offers information on a variety of topics such as collateral recovery, real estate, probate, just to name a few. We will send you a link to the library in our follow-up email. Again, thank you for attending, and we wish you all a great rest of the day and a great weekend. And thank you, Geoff.
Thank you.
Okay.